All right, everybody. This is John Martin again, trial lawyer from the KJC law firm here in Boston and Worcester. And Tom, I'm very glad to have you here today. This is Tom Button. He is a lifelong law enforcement officer, chief of police, and many other things. Who's also now an expert in police practices and specifically the use of force. So, Tom, thanks for being with us today. Really appreciate having you here.
I appreciate it, John. Thank you for having me.
Now, I want to talk to you specifically about what's been in the news recently with Minneapolis and the death of George Floyd. But before we get into it, could you tell us a little bit about your professional background and all your experience as a police officer?
Yeah, just briefly, I have about 45 years in police work. Most of my career was in the New York State Police, where I retired as a captain, which at that time was the assistant troop commander of a troop of 10 counties with 27 state police stations, of about 700 personnel. I left that job, retired, to take a police chief job. I came to Massachusetts as a police chief in 2 different towns for about 15 years. And then since then, I've been doing consulting, written some books, done some expert police witness kind of work, some teaching, both online and in the classroom. And that's where I'm at now. I have a master's degree from Western New England University in criminal justice administration. I attended the FBI National Academy. Obviously, lots of trainings throughout my life in a career in the state police executive command, leadership, they call public speaking, teaching, and go on and on and on as far as where I was trained in the state police. But that's basically it.
Yeah, so you've been doing this your entire life, and have you personally conducted investigations into an officer's use of force while on the job?
Oh yeah, I started in 1979. I became a sergeant in the state police, where they would send you, they would assign you to conduct the lower level types of complaints, injured prisoners, and those kinds of things. And then as I became up through the ranks as a lieutenant captain, I actually did deadly physical force, both on and by state police members and to other people. And then as a chief of police, I conducted and as I continued, if I didn't conduct them on my own, I reviewed them or supervised them and managed them. So probably between all of those things, conducting them myself and reviewing them and managing, supervising, we're into the thousands probably.
And tell us a little bit about I don't know, kind of your perspective. There's a heated national conversation right now about law enforcement and training, intent, and things like that. And from your perspective, I understand that you're quite proud of the industry and the progress that they've made from your standpoint regarding policing and community policing, stuff like that. Is that right?
Yeah, I think that the police, they have to do everything they can in a positive light, because the nature of their job is negative. The police officer's job mostly is negative. You give a ticket, you tell them they can't do something, they arrest somebody, you restrain their activities, whatever. And so just by doing your job, you tend to have to take on a negative aura. So I think that it's really incumbent on the police officers individually and as organizations that they do whatever they can to increase the number of positive interactions they can with the community to engender that trust that is necessary for police officers to do their job. When you're talking about the use of force, every individual department, whether it be a state department, a city department, or a county department, or a town department, they have their own rules and regulations. But generally speaking, you use that amount of force which is necessary to either to affect the arrest or control the situation, whatever. And what I used to teach people when I taught at State Police Academy and in other areas was to use the least amount of force that you can to effect the arrest or to do your job. Now, that isn't always the case with all police departments. They usually say to use that force if necessary, which is necessary to effect the arrest or to do your job. But we've seen in some instances, that the police officers have gone over the line, or at least it appears to, without having known all the facts or whatever. But if we're talking about the George Floyd situation, I was saddened when I saw that, because I didn't feel that there was any way that that could be justified, or you could explain that away in any shape or form or manner. And that when I saw that, I thought this officer was so far outside the bounds of what was right, what the training would be, and what he was supposed to be doing, that it couldn't be justified. And I was sad for the profession. I knew this was going to happen. My son is a Connecticut State Trooper, and I told him, I said, this is bad. This is going to hurt the profession. It's going to hurt all good police officers. And you have to understand that 90 to 95 of all police officers are good, and they want to help people.
So let me ask you to kind of take us through how you as a professional went from watching the video to formulating your opinion, because I assume that for somebody who's trained and versed in use of force, it's different than those of us who are watching a video and are not trained in police policies, procedures, or the laws. Is that right?
I would imagine. And we have to understand that, you know, a video, even 2 or 3 videos, is only representation of that particular segment of the situation. And we're reading just like everybody else is. I'm reading and I'm trying to figure out the whole story. But there came a point in time when you were watching those videos that it didn't make any difference what kind of information you had. You saw what you saw. You saw Officer Chauvin with Floyd, who was handcuffed behind his back, and there's 2 or 3 other officers on top of him, or laying on him, restraining him. And now this officer's got his knee in the back of his throat, the side of his throat, the carotid artery area. He's saying, I can't breathe. And here's the thing: a lot of people don't understand this, but when a person is in custody, which once you handcuff them, they're in custody. They're not in the process of being arrested anymore. So now you have a different situation. The guy was in custody, and he may have been fleeing around, and you know, there's a term called excited delirium, or you being uncooperative, or whatever. It doesn't make any difference. The police officers are entrusted and responsible to safeguard that defendant's life, his health, and his well-being. And at some point, he goes, I can't breathe. Okay, you have to respond to that. You have to either take your knee off of his throat, or you have to roll him over on his side so he can breathe, or whatever. And then, from what I've read, and I've read it in 2 or 3 places, one of the other officers took Mr. Floyd's pulse and told Officer Chauvin, I've got no pulse. And he continued to lay on the guy's throat for another 3 minutes at most. That's incomprehensible. That's unjustifiable. There's absolutely no way that you can justify that, no matter how pro-police or how much leniency you want to give to the situation.
Yeah, well, let's talk about that word justification for a moment, because my understanding is that from cases that I've done, and for just a full disclosure, I've worked on a use of force case with you. So I know firsthand your level of expertise. When it comes to justifying the police officer's conduct when they use force, there's a very specific standard that'll be applied by the courts. Can you tell us a little bit about the standard of review as to whether or not an officer's use of force was appropriate?
Well, by the Supreme Court states that we have to use what they call an objective reasonableness. And that means that in objective reasonableness, and the objective reasonableness that has to be used is that of which a police officer, not a common person, not a person on the street, but is what's happening with a reasonable police officer, given the facts and circumstances at that particular time, not Monday morning quarterbacking, not beforehand, at that particular time. Would a reasonable police officer do the same thing? Is that justified otherwise? So that's what I think a lot of public don't understand about the use of force police officers, is because the police officers are trained. The police officers are trained to not let someone get their gun. Police officers are trained to be aware of the fact that someone could have a weapon on them. They're trained that people who are under psychosis or mental, they're super strong. You know, so you're in this mode of being aware of all of these things. And then you also have the fact that the police officers are human. They're human. They get scared. They get nervous. They get worried. They don't know if they can take this person, physically subdue them and whatever. So you have to take all those things into consideration, and you have to take the facts and circumstances at the time, and then it has to be decided, was this reasonable? And was it reasonable by a police officer in that person's shoes at the time? And that's called objective reasonableness is the standard that has to be used.
And one thing that's often hard for plaintiffs in civil cases regarding use of force is that the Supreme Court specifically instructs you can't look with the benefit of 20/20 hindsight. You have to look at this split second in time in which the officer was making the decision. So they can be, there can be a lot of dispute in some cases as to whether or not a reasonable person would have felt like they were, in fear for their life.
Yeah, there's a thing called looks awful but lawful. Mm-hmm. There are situations where what the officer did doesn't look good to the innocent bystander or to the general public. It doesn't look good, but the actions were in fact lawful under the law, under this reasonable objectiveness standard.
Mm-hmm. So applying, the techniques that you would use back when you were investigating use of force cases for law enforcement, or even the techniques you would use now as an expert when you're retained independently by attorneys or different departments. What was it about the George Floyd case that made you decide that this was unequivocally excessive use of force?
Well, again, at some point in time during this situation, you have to realize that the man is handcuffed with his hands behind his back. Mm-hmm. So he's in custody. And even if he's psychotic or he's involved in excited delirium or he's still thrashing around or spitting or whatever, that's something that the police officers have to control, whether they take out shackles or leggings or rope and tie his legs or whatever. You don't lay on him with four people, and you certainly don't put your knee in the guy's throat for that protected period of time. Again, you can use the force you need to get the situation under control. But when the man is on the ground and he's laying there face down and he's handcuffed behind his back, that in and of itself is hard, because when a person's handcuffed behind their back, their chest and their lungs are compressed by the ground as it is, and then you got four people on top of him, mm-hmm. And now he's saying I can't breathe. But here's the thing that, again, from what I've read, and again, I'm going by what I've read. One of the other officers during this time takes his pulse and tells the Officer Chauvin, he's got no pulse. Well, now, Officer Chauvin was the senior most officer at 20 years on the job. He was the arresting officer. He has an obligation to safeguard that defendant's health. He should have, at that particular point in time, called for medical attention, called for EMS, and done whatever he could to resuscitate, revive Mr. Floyd, not lay on his neck for another 3 minutes. That goes beyond the pale. When I saw that, I was disturbed. But then when you realize that there was 3 minutes where he laid on his neck with his knee, kneeled on him, compressing his cardiac after he had been told the guy didn't have a pulse, that's unconscionable.
Well, so just going back a couple of minutes in the interaction, I'm going to assume that the majority of people who are being arrested don't want to be arrested, and that officers will very frequently have people who are saying to them, you're hurting me, let me go. There's, something about this event that's jeopardizing me, and you should stop. How are officers trained, or how are they supposed to differentiate between when people are just saying things that might not be true in order to stop the arrest versus when there's an actual medical emergency? Because every time somebody says, I can't breathe, you can't expect the officers to stop the arrest, right?
No, that's true, but you have to understand that the defendant gets the benefit of the doubt. If he says I can't breathe, if he says my handcuffs hurt, I mean, I can't tell you how many times I've arrested someone, oh, my handcuffs are on too tight. Well, you stick your finger in and you make sure that there's room for them, that you're not cutting off circulation. You have to check out every single one of their complaints and their claims, so to speak. If it comes down to it, you get to call ambulance or EMS. That's just part of the job. That's part your job. Once the person's in custody, is to safeguard the defendant's health and safety. Whether it be helping them in and out of the cars, where you see the fact that most officers will hold their head so they don't bang their head in getting into the car, assist them out of the car so they don't fall face first when they're handcuffed behind your back. You're trained that subjects, once they're in custody, they're yours. You own them. You have to protect them.
Well, that brings up an interesting point about the autopsy results, which showed that Mr. Floyd may have had some pre-existing heart disease and may have had some level of intoxicants. It wasn't very clear to me, at least on what I've read so far, whether it was current or from earlier usage. But when you say that once you take somebody into custody, in the law we call that the eggshell skull doctrine. Once you bring somebody in, if they have heart disease, if they have intoxicants, if they have pre-existing conditions, you take all those pre-existing conditions and responsibility for them into your custody. Is that right?
Yeah, that's true, and that's very important. Is that, again, when you take someone into custody, the law provides that you can use the force necessary to take someone into custody. And if unfortunately during that you have to wrestle with them, and then the person gets a broken arm or teeth get chipped or whatever, well, if you can show that they resisted and you had to wrestle with them or whatever it is, that's on them. But once they're in custody, once you've got handcuffs on them, they are in custody. Now you have to safeguard them all, so to speak. Mm-hmm. And the person starts having a heart attack, you call the ambulance, you can start CPR. If a person falls down and falls out of the car and gets cut, you provide bandages and call EMS or the ambulance. You don't lay on the guy for 8 minutes when he's handcuffed behind his back, and you don't lay on him for 3 minutes after the other officer tells you he's not, in fact, breathing.
Mm. Now, in the criminal complaint, it says right at the end that the police restraint was a contributing cause to his death, which is, the basis for the charge. And it's very significant evidence against the officer. But it also went on to say that officers are trained that this manner of restraint is inherently dangerous. Can you explain to us what that means?
Well, like I started to say earlier, the man is, however he's acting out or whatever, but at some point he's in custody. And you can see he's in custody. He's handcuffed behind his back. All right, now when your person is handcuffed behind their back, that's uncomfortable as it is. Even just sitting in the car, that's uncomfortable. And you put them on the ground, now their lungs and their chest is compressed, and then you stand on top of them and you put your knee into the neck area. These are things what they call takedowns and come-alongs. These are tactics that are used for a person who is fighting you and violently resisting, etc., and has not yet been arrested or in custody. This man was in custody. This man, again, had been restrained. He's in custody. And once the guy's got the handcuffs on, he's in custody. You have to do what, I've seen officers who take rope and tie their feet up because they're kicking, officers are going to kick the windows out and whatever. And that's just what you said. That's what you take on. When you arrest someone, you put them in custody, that's what you take on.
Now, how about the other officers? You mentioned them a couple of times. One of them alerted Chauvin to the fact that Mr. Floyd had no pulse. Do you see any liability or any policy violations on behalf of the other officers who didn't intervene and take Chauvin off of Mr. Floyd's neck?
Yeah, I do, and I don't know Minnesota law, but and there's a dynamic there where I've read where two of the other three officers were still in their field training, which would have meant they were on probation, which meant they just got out of the academy. And there's a whole dynamic there. They're probably scared. They're probably doing what senior officers are telling them to do. They don't know what to do, and they're taking lead from someone else. But at some point in time, every person is responsible for their own actions or inactions. And a police officer who is sworn to uphold the law, at some point in time, all police officers there at the scene would have known, should have known, did know that what Chauvin doing was wrong. They should have pushed him off, pushed his leg away, pulled him off, or whatever. This isn't about me, but I have a scar on my hand here. I'll show you from here. Back in 1980, I was a station commander in the state police. one of the troopers went to a larceny call, gets there and gets assaulted by 5 young bad guys, and we all show up at the scene, and there's fighting and shoving and whatever. And one of the guys that was most responsible, we get into custody. I actually put him in the back of my car. He's kicking a lot like Mr. Chauvin was, trying to kick the windows out, etc. And at some point, one of the other investigators, not a uniformed trooper investigator, starts jabbing at this particular guy, who was handcuffed now with his hands behind his back in the backseat of my troop car, jabbing at him with the nightstick. And I'm going, like, what are you doing? This guy's under arrest. You can't be doing this. He's not a threat to you. You can't be hitting him with a nightstick. And I stuck my hand to prevent the nightstick from hitting the kid, and I end up with about a 3/4 of an inch scar. I've had for the rest of my life, and I had a lump there. We got into, myself and the investigator got into physical confrontation back at the station over the situation. Mm-hmm. But you can't do that. You can't allow someone, he's your prisoner. You can't allow someone to be abused, especially in that fashion. You have to take the action you have, that is necessary to safeguard the guy's health.
That's amazing. Now, how about the citizens standing nearby who are videotaping it, and thank God that they were? If they had tried to physically intervene, because there's one point in the video, if you saw, just using their words, just telling Chauvin, get off him, stop it, you're hurting him, some even more aggressive language than that. Chauvin pulled out, it looked like pepper spray from his shirt, and aimed it right at the citizens. So can you tell us, would it have been a crime if the citizens actually tried to intervene? Well,
again, I don't know Minnesota law, and there's a good Samaritan statute in most states. There also is obstructing government administration, interfering with police officers, resisting arrest, and assaulting police officers. In a dynamic is what you saw, the person who would have pulled the officer off of Mr. Floyd probably would have been heralded as a hero, and probably would have been, and probably would have been invited to the White House. I don't know, but it certainly would have saved saved Mr. Floyd's life. But it's always I want to say nebulous when a civilian tries to get involved in between a police officer doing their quote official duties. I wouldn't, in fact, suggest that. I recommend that. But I have to say, having watched this, I know that if I was there and I'm retired, I'm no longer, but I would have pulled them off.
Mm-hmm. It seems like such a difficult thing to expect of a citizen, though, with people there who are armed, who are trained, who are pointing pepper spray, who are very clearly ready, willing, and able to get extremely violent. It seems like a really tough thing to expect the citizen to intervene and stop a police officer from breaking the law.
Well, yes, the other police officers, didn't do it. So you can see the level of responsibility there, and apprehension, and anxiety, and angst in a civilian. Even though they wanted to, you could see that there were several people who were shouting from the crowd that they wanted to.
Mm-hmm. So what's your profession, if you have one? What's your professional projection or opinion of what's going to happen? Do you think more of the officers are going to face criminal charges?
Yes, I believe that when it gets all said and done, at least the one who is not on probation should probably face charges. And again, probably even the ones on probation, where there's a dynamic there that they're like little chickens, they're doing what the senior guys tell them to do and whatever. But certainly anybody, any of the police officers standing around, it doesn't have to be the people that were in fact on Mr. Floyd. There were officers standing around. Mm-hmm. There were officers standing around who should have said, "Hey, this guy needs help. What are you doing? Get off him."
So, I take it then you support the city's decision to terminate their employment. Do you support the decision to charge Officer Chauvin with, I would refer to it as murder 3, but I think in Minnesota it's specifically called murder in the 3rd degree or 3rd degree murder. I'm not sure the specific language they use in their statute, but.
Well, I don't know Minnesota law. I don't know the dynamics there. I know that they said this was the quickest they ever charge a police officer. When you charge a police officer, you want to make sure when you're right, you want to make sure you can make the charge stick. As I see it, at some point in time, an intent culpability comes in there. There's a situation where we've talked that.
let me just, sorry to interrupt you, but
Yeah.
just to make sure the other people know. So the difference between, there's murder 1 and murder 2. Those
Yeah.
are various degrees, and then there's murder 3. For 1 or 2, first or second degree murder, there's going to be an element of intent
Right.
that the individual intended to kill the person, or at least intended to do something very, very harmful that resulted in the person's death. But for murder 3, it just requires a showing that he acted with willful or wanton reckless disregard for the person's safety. In this case, the prosecutor, for whatever reason, made a strategic decision to remove the element of intent. So just to make sure everybody listening has that understanding, if you want to continue where you were.
Yeah, and I think that we now we get into very technical terms. There's criminal negligence, reckless, and what do all those mean? But certainly, at some point in time, even what we see was certainly reckless and negligent, and we could probably even cross into it had a depraved indifference to human life, which now you're getting into the culpabilities of higher levels of crime when you get into the depraved indifference to human life. But at some point, especially at the point where he's being told, hey, this guy hasn't got a pulse anymore, and he stays on for 3 more minutes, you have to show that to me shows a serious depraved indifference to human life, which now you enter into the culpability of at least murder second, from my perspective. But I'm sure that the district attorney or the state's attorney, county attorney, whatever, the prosecutor, they want to see the charge stick. So I know that a lot of people say, well, why aren't we charging higher? Why aren't we charging higher? Well, they can be done down the road. If they just put the thing in the grand jury and they conduct a more thorough investigation, take statements from all the people involved, file all their charges. You can always elevate the charges, but they wanted to take action because of the social unrest and the need for the societal unrest that was going on. So they wanted to show they were taking action, and they can always increase the charges later on.
And then final one, and I know I'm asking you to read the crystal ball here a little bit, but what do you think's Chauvin's outcome? You think he's got any defense here at all?
Well, you're an attorney. I've been in the police for 46 years. You can't ever try to guess the outcome of everything. Look at the Rodney King thing. The Rodney King situation, they were found not guilty. Then 2 of the 4 were found guilty in a federal situation. So you really can't. I mean, look at O.J. Simpson. He was found, not guilty, but then he was found guilty in a civil trial. You really can't try to second guess that. But I would say that if the prosecutors do their homework, they cross their T's, dot their I's, they'll get a conviction for something out of this guy. They'll get a conviction for something.
All right. Well, listen, I know that you're exceptionally busy, and I really, really appreciate your time and your insights today. So, thanks for coming on here and talking to me.
I appreciate it. Thank you for having me.
All right. See you, Tom.